45, matter of Bikman. Counselor, do you want some rebuttal time?
2 minutes, Your Honor, please.
2 minutes.
Thank you.
Go ahead.
Good afternoon, Your Honors. My name is Marta Ross, Assistant Corporation Counsel for the New York City Loft Board. Your Honors, the Loft Board interprets the right to sell improvements as a right that only the residential tenant qualified for protection may assert, giving plain meaning to the term residential tenant qualified for protection as set forth.
But it's not so unusual for people's claims to pass to their estates. Don't you have to show there's something special about this one, that it's extinguished on death?
Your Honor, the statute here is clearly worded. It is only...
It doesn't exclude the other interpretation, does it?
It doesn't exclude it, no. There are other sections of the Loft Board that provide for succession rights.
And what about the spirit of the whole thing? In relation to what the statute is about and in relation to who should get the benefit of the improvements, why is it that the interpretation that you're giving, and again, you're saying it doesn't exclude this broader view of it, why is it that that's in keeping with what the statute's supposed to be about, as opposed to what the regs lay out?
Well, looking at not just the regulations, but looking at the actual legislative findings as outlined in the municipal dwelling law, there is an overriding concern to protect the public, I'm quoting from the statute, designed to protect the public health, safety, and general welfare. And that is the concern of the Loft Board here. Yes, there's a balancing of interests.
Suppose you had a statute that said a person whose property is condemned may claim the proceeds. It doesn't say a person or his estate. The estate could still claim, couldn't it?
Your Honor, I'm not sure. In this case, I don't know what the answer to that would be, Your Honor. But in this case, the statute here is clear. And here we have, let's focus on the rational determination and interpretation of the Loft Board. That is the issue here, how the Loft Board interprets the statute. We argue that it's a rational.
You had a strong dissent even within the Loft Board, right? As to the view of this.
Yes, by the tenants.
It's not open and shut either way, right?
But the order here at issue does not afford the estate the right. And we're saying that that's a rational determination based on a balancing of interests. And we're basically trying to eliminate any potential excuse that an owner may have to delay legalization. We're trying to move the process along.
Why shouldn't the tenants, if you talk about the spirit of this thing, why shouldn't the tenant's estate be able to recover the amount that was put in by the tenant? It's different, isn't it, if the tenant just leaves and leaves the landlord holding the bag. Then we understand that we want the landlord to be able to sell the fixtures or whatever it is. But why in this situation isn't it more in keeping with basic fairness and the intent of the Loft Board to let the estate recover the amount?
Well, that's the crux of our case.
That's
the crux of our case is
why is that a better interpretation?
Our interpretation is consistent with the mission of the Loft Board, which is to promote legalization of these buildings. We're trying to eliminate years of estate squabbling and years of limbo.
Is it totally the delay that's the basis of your view?
The delay that can
that
result
is my
in
cause. Is that the real thrust of your argument?
That is the thrust of it. That is the thrust because, again, the legislative findings couldn't be clearer. We're trying to bring these buildings up to code. The owners have a duty. It is incumbent upon them to bring these buildings in compliance with the building code.
Even where it may result in quite a windfall for a building owner? I mean, I could envision where a new residential tenant goes in, spends $100,000 renovating the loft. 6 months later, they drop dead of a heart attack.
Well, again, Your Honor.
The building owner gets the benefit of all those improvements?
Yes. Yes, he would, because, again, we are looking at an overall policy here, not just a particular case.
But isn't there also a general policy against forfeiture? I mean, it's not just the windfall to the landlord. It's you're taking away an investment that the tenant has made without – I mean, are we allowed to do that without compensation?
Yes, Your Honor. The tenant here resided in a rental property that was under rent regulation. The tenant put in improvements that tenant enjoyed during the course of her lifetime. The tenant did not put these improvements in as a benefit for her future estate. That is not the purpose.
Well, but anyone who makes an investment, yes, I want to enjoy it for my lifetime. But if God forbid I die tomorrow, I'd like my kids to be able to cash out. I wouldn't want to forfeit it to my landlord.
Well, Your Honor, then the legislature should have afforded that right to an estate. Here the statute limits it to a residential occupant.
Yeah, but your regs are defining what that means, right?
Well, the regs define
the regs aren't really entitled to deference, right?
Well, the statute says residential tenant qualified for protection.
You mentioned, are there other provisions of the statute that talk specifically about succession?
There are. Not the statute, the regulations. The statute, which of course gives the loft board 286-6, affords the loft board the right to establish rules and regulations regarding such sale of improvements. That's set forth at 286-6. The loft board shall establish rules and regulations regarding such sale of improvements. The loft board has clearly defined the residential tenant to be an occupant. 2-09 equates tenant and occupant.
But that's the regs, not the statute.
Correct, Your Honor.
Yeah.
The regs also provide for succession rights of occupancy. So the loft board has envisioned scenarios where a succession may be involved. In terms of improvements, the statute is clear.
In a situation where succession would be allowed, not here, obviously.
Not here.
Where succession would be allowed.
In terms of occupancy?
In terms of somebody who had been living with
for
an
2
elderly
years,
parent
correct.
for 2 years or whatever, within the confines of the statute. Obviously, they would inure to the benefit of the improvements, right?
Correct. Because they would then qualify as a residential tenant qualified for protection. They're afforded rights under the statute as opposed to an estate.
Can legally live in the apartment.
Correct.
If Ms. Bikman had been successful in the holdover proceeding, and she was a residential tenant now, then she would inure to the benefit of those.
That would be something that would have to be considered by the loft board and perhaps to gone to an oath hearing.
Are you saying that the death of the tenant, I think that is what the loft board is saying, is equivalent to abandonment?
Correct, Your Honor.
Does that make any sense?
Yes, Your Honor, because in this case, because the loft, first of all, that is a scenario that the loft board envisioned in establishing its regulations.
So you die and the landlord gets, in Judge Graffio's description, a windfall. I mean, could you describe it as anything else? You're saying it's a windfall,
describe it as a windfall,
but it's okay.
Yes, because again, we're looking
Okay.
at an overall policy
Yeah.
and
So
the balancing
how
of
does
interests.
the tenant protect, how does an elderly tenant, let's say, protect against the loss of that asset if they want that asset to pass to their heirs?
We're saying
They
there's
have
no
to move out- they have to
statutory
move out.
or legal authority for that tenant to do so while the tenant resides in the rent
So
control
they have to move out of the apartment? That's the only way to protect the
to
investment?
sell the improvements, correct, Your Honor? That is the only statutorily authorized way to sell the improvements.
Okay. Thank you, counsel.
My name is Charlotte Bikman. I'm the administrator of the estate of Minda Bikman, and I'm appearing pro se. The loft board's argument ignores the second issue raised in the administrator's papers, which is that Section 286 of the loft law does not permit deregulation unless the owner purchases the improvements. The loft law does not provide for deregulation on the death of the protected tenant. And in addition, for example, the rent
So your point is that if they'd wanted to there's no particular reason for them not to create a forfeiture on moving out of the apartment. If they wanted to make a forfeiture, why wait for death?
I'm sorry, Your Honor.
I guess I'm trying to paraphrase your argument. You're suggesting that if the loft board just wanted to get all the impediments out of the way and stop the nonsense, they could have said that every tenant who moves out forfeits the improvements. Or if the legislature wanted to.
I suppose, Your Honor. I mean, they could have just said that these premises are regulated only for the life of the Article 7C protected tenant, and then with the amendment with regard to succession or family members succeeding to such rights. The fact is that what the application of the argument that the loft board proposes is that whenever a tenant dies, the premises are deregulated, and that is contrary to the purpose of the statute, because the purpose of the statute was to increase the supply of rent-stabilized legal residential premises. And so when they discuss that, you know, the purpose of the law is legalization, that's correct.
What about the delay issue, counsel? Your opponent is saying that the delay really causes a problem that's contrary to the purpose of the loft board.
Well, in effect, that's a conclusion which is not supported.
Well, this case went on for a number of years, correct? I mean, it's quite a number of years since the date of death from when this is being resolved.
The estate had a representative during the entire course of the proceeding.
You're saying that they could have shortened it considerably by writing you a check several years ago?
That's correct. And that is what rational landlords do. The estate's right to compensation has no effect on legalization. The legalization process is under the Department of Buildings. The legalization process involves building permit, completion of the required health and safety repairs, and then obtaining a certificate of occupancy, which to obtain that, the Department of Buildings has to inspect and certify that the minimum necessary health and safety.
And that was all done here, right?
No, it wasn't. And it isn't to this day. It is still an interim multiple dwelling. I checked the loft board's website to confirm that. My own examination of the website for the Department of Buildings shows that they've renewed their building permit repeatedly, and there is no evidence on the website of any temporary certificate of occupancy or any certificate of occupancy.
You say the policy is essentially to increase the supply of rent-regulated housing?
Yes, because the
why then is it okay for the landlord to buy the fixtures and deregulate?
Because the statute was threefold. One purpose was legalization and to increase the supply. The other was that the statute in Section 286 recognized the equity investment of the loft law pioneers. This is what distinguishes.
So they offer, in order to protect the investment of you're a loft law pioneer if you did it before it was legal, and to protect their investment, it essentially offered the carrot of deregulation to the landlord?
That's correct. And as a matter of fact, the loft board ignores the fact that Section 286 provides, upon purchase of such improvements, the owner of any unit subject to rent regulation pursuant to this article, and so on, shall be exempt from the provisions of this article requiring rent regulation. So, in fact, the statute specifically states that the purchase is a precondition.
But if the idea is to have more rent-regulated housing out there, maybe I don't understand it, but it sounds to me like every time a tenant either moves out or dies, the landlord it's going to be deregulated unless the tenant forfeits his investment. So how are you increasing the supply? You'll never have a vacancy within a regulated apartment.
According to the website, out of some 600 buildings that were interim multiple dwellings, 400 have passed into rent stabilization. So it does increase the supply, because for those owners who have complied with the loft law, if I may, after obtaining the certificate of occupancy, the owner is required to register the building as a multiple dwelling.
Yeah, but I mean, as I understand, these should mean if I'm understanding these right, all those apartments that are now regulated should be ones with the same tenants still there, because as soon as there's a vacancy for any reason, unless there's a forfeiture, it's going to be deregulated.
No. For the apartments to go into rent stabilization, it's then under the rent stabilization rules.
But you retain your right to sell your fixtures even under rent stabilization, don't you?
That is correct. So in other words, this is a balance that the legislature made. They did provide the owners with the right, particularly, I suppose, if they wanted to have it revert to a commercial use.
If you prevail, who pays you?
The owner.
Why?
Well, if actually nobody can force the owner to purchase rights, but the way that it was handled below is that they annulled the loft board order that essentially said the premises are deregulated on the death of the tenant and there's no right to fixture compensation. So the Supreme Court annulled that order, remanded to the loft board for an appraisal of the fixtures because they have procedures where there's a dispute as to the exact value, and said that the premises were re-regulated pending the sale of the fixtures.
How does that work? How would that work in this case where the occupant passed away, 13 years ago, right? So what's the value of this kitchen and bathroom now? Does there need to be a whole new appraisal?
Well, I think that the value would have to be determined as of the time when 2001, when the application was made.
That would set the market value?
Yes.
Do you get interest from 2001?
At this point, I haven't even thought about that.
So the reason the owner isn't here is because, depending on what we do, if we were to reverse, he then comes back into the picture if it's reversed?
Well, it's remanded back to the loft board for an appraisal. And then when that appraisal figure is determined, the landlord makes a choice. Do I want to pay the appraised figure and have a deregulated apartment, or do I want it to continue under rent regulation?
And any other defenses he may have or issues he wants to raise, he would raise then?
I don't know that the remand is that extensive. I think the remand was that with respect to the appraisal. So whatever the value is, that actually
well, I don't mean to be facetious about it, but they're not here, which seems really odd that we're litigating this without what I would think would be a necessary party unless it's on a limited issue, that being what we've been discussing. If it was much more than that, I would think they would want to be here to say that you're not a proper party, that the estate has been closed, or that any number of issues they could raise that aren't being raised now because this isn't a dispute apparently that involves them.
Well, the landlord proceeded by summary judgment, and they obtained the ruling that they requested, which was that the estate has no rights. And so I don't know what issues would be left after that.
So there's a proceeding before the loft board to which the landlord was a party?
Yes, loft board order 277. This arises in the context of Article 78. They participated.
And you sought Article 78 review of what the loft board decided. And so nobody said, hey, wait a minute, the owner is an indispensable party?
That's correct.
I assume the owner does know that something's going on?
I would think so. They have they were represented by a law firm that has constant cases.
Has this loft been vacant since 2001?
I doubt it.
Okay. Thank you. Councilor Rebuttal?
In terms
Do you know, Councilor, has the loft been vacant since 2001?
I don't know, Your Honor.
Okay. Sorry. Go ahead.
I do know it's been deregulated and market rate rent was granted to buy the first apartment. And that rent was paid.
So somebody, if a new tenant moves in, has moved in and is paying a market rent right now, and Ms. Bikman prevails in this case, and the parties can't reach an agreement on the fixtures, what's going to happen?
Well, again, I don't know. Perhaps the apartment is vacant, but if a new tenant is there, then
I suppose the new tenant could have struck it rich. He could suddenly find himself in a regulated apartment.
No, well, again, we don't know exactly what the status is. But in terms of precedent. This Court has addressed the issue of tenant and occupancy in Rubenstein and Dikovsky, where this Court stressed that you need to look at the definition of the term.
But weren't those cases where, I mean, those were cases where there was a state-created entitlement was being essentially bought out. Here, this is stuff she put in with her own money. Isn't that a difference?
And that would have been, pursuant to statute, a right that she could have asserted, and not a windfall to the estate. This is something she was authorized pursuant to statute.
Does windfall really describe what the estate gets here? I mean, isn't whether the statute requires it or not, isn't forfeiture a better term? That if you build a $30,000 kitchen and your landlord gets it for nothing, that's a forfeiture. You're getting the $30,000. Doesn't sound like a windfall to me.
Again, in terms of what the Loft Board found here, the Loft Board is interpreting the law in furtherance of its mission, of its statutory mission, to stress that these buildings need to be brought up to code, to accelerate the legalization process. Putting an apartment into estate limbo for what could be years. In fact, this Court did note in Rubenstein and Dikovsky the not infrequent discourse.
So whose fault in this case is it that it's in limbo?
And, Your Honor, we have to look not just at this case. We need to look at the overall policy.
Okay,
and that's what we're trying to stress here.
Thank you both.
Thank you, Your Honor.